Well, good morning, everybody. It's 9 o'clock on the dot, so we're going to go ahead and get this party started. First, just a couple of housekeeping things. I want to make sure everybody remembers to complete the the CEU sign-in sheet, and then also don't forget to use the links to to complete the quiz afterwards and the course evaluation afterwards. I want to make sure you guys get your CE credits for being here today. Hope everybody's doing well here on Friday the 13th. It's always a good time for me because the day I broke my neck was a Friday the 13th. So I always consider calling in sick to work on that particular day, but I'm not suspicious at all. Anyway, superstitious, whatever. Anyway, today we're going to be talking about a topic that's a little bit different. We have talked about restraint here in recent years, trying to improve our restraint education because it's something that gets neglected, as you know. However, there's a facet of it that we're going to concentrate more on today than what we have in the past, and that is the legal side of patient restraint and involuntary transport in general. We're going to look at some of the legal issues. We're also going to take a look at a couple of the big controversial cases that took place here within the last few years regarding the use of ketamine for chemical restraint in a few patients that ended up having some very bad outcomes. So we want to talk about that and the lessons learned and see what we can do to protect ourselves from experiencing a similar restraint-related disaster. So the title of today's message is Care versus Custody. When does involuntary transport cross the line? So I'm obviously not an attorney. I don't claim to be, but I can read a statute, and I've done quite a bit of research on this topic. And given the litigious nature of our society, I think it's really worth our while to be aware of the things, the legal ramifications of things that we do on a semi-regular basis to protect ourselves and our families and keep ourselves out of court if at all possible. So I want to test your knowledge here, and feel free to chime in or use the text box, whatever you want to do, to answer any of the questions that I pose in this presentation today. What I first want to do is quiz you on some very basic knowledge of the law. How many of you could recite for me the Fourth Amendment or summarize what it's about? It's not commonly taught. What about the 14th Amendment? Surely you can recall the 14th Amendment. No? All right, how about, this one should be obvious, USC 42 Section 9501, also commonly referred to as the Mental Health Patients Bill of Rights. I can almost feel everybody's kind of furrowed brows right now. And that is perfectly okay because you're not alone. This is really the problem that we're facing in this particular arena, that these laws have a lot of bearing on the practice of involuntary transport, involuntary patient care, patient restraint, and yet we don't talk about these things in EMT, paramedic school, or anything else, even continuing education. And then the last thing is Theyre versus Ohio. I know there's some of you that have some law enforcement background, and this should be very familiar to you, but to the rest of us, it's probably nothing that we've really ever heard of before, but we're going to talk about that landmark case and how it applies to the 14th Amendment and our use of restraint and involuntary transport. So just to answer the first question of the Fourth Amendment, I want you to key in on the lines that are underlined on your screen, the underlined, the red marks there. It says the right of the people to be secure in their persons against seizure, unreasonable seizure. When you put someone in restraints or when you simply require them to go to the hospital without their consent, you are in fact making a seizure of a person. And that puts us under the microscope here of the Fourth Amendment. And this is just one of the reasons why we always need to have a reasonable justification whenever we perform involuntary transport or use restraints. And get this, you don't even have to lay a finger on the patient to violate his Fourth Amendment rights. And this is where the Terry versus Ohio case came into play. It says that a seizure of a person occurs when someone, by means of physical force or by show of authority, has in some way restrained the liberty of a citizen. So think about this. If, in other words, if a reasonable person would not feel free to terminate the encounter with you and walk away, if they feel like they have no choice but to either go to the hospital with you or be forced to go to the hospital with you, if they feel that that is their option, that is, in fact, a seizure. Simply because of your show of authority, they feel like they're not free to walk away whenever they choose. And that brings me to a very common occurrence in our industry, and that is this statement right here. Maybe you've heard it before. You can either go to the hospital with them or go to jail with me. Anybody ever heard any law enforcement officers make that statement? I have to say, anytime I hear this, I cringe. And I wasn't comfortable with it when I was on the road, and I'll never be comfortable with it because this is just simply a stupid thing to say. So let me explain. First, let's call it what it is. It's a threat. When someone's being difficult, refusing to go with us voluntarily, we say these ridiculous words for the sole purpose of coercing them into going with us, quote unquote, voluntarily. But honestly, to call them voluntary, at that point, it's entirely untrue. It reminds me of the scene in the movie RoboCop where he says to the bad guy, "Dead or alive, you're coming with me." I mean, no matter what the guy says or does, the reality is that his opinion doesn't count for squat. He's going whether he wants to go or not. Even if he says, okay, I'll go peacefully, that's not the same thing as being truly voluntary. It's being voluntold. And legally, that places us on some thin ice. Likewise, just threatening a patient with the use of restraints is enough to qualify as false imprisonment and assault. So, for example, if you say to a patient, if you don't behave, I'm going to restrain you, that's a bad idea if you don't actually have justifiable cause to actually use restraints on that patient. So don't threaten. Either use the restraints or don't. And if you feel justified in threatening their use, you probably have plenty of reason to just go ahead and apply them. So the second reason why you want to avoid this infamous phrase is a little matter of scene safety. How do most people respond to ultimatums? How do you respond to them? Do you feel all warm and fuzzy when someone threatens you, or do you feel more like Bruce Banner just as his skin begins to turn green? So with that in mind, throwing these threats around in a situation that's already emotionally charged, it's like throwing gasoline on a fire. It's not likely to make things better, but there's a good possibility it might make things a whole lot worse. And to me, at least, that seems like a very stupid thing to do before you get sealed up in the back of an ambulance with this guy. So what on earth do we hope to accomplish by issuing threats? What's the point of poking a hornet's nest with a stick unless you just really want to get stung? If the patient has done something bad enough to truly make jail his only other alternative, he probably doesn't belong in the back of the ambulance in the first place. Just a little food for thought there. So could that threat, just making that statement, can you go, you can either go to the hospital or to jail. Making that statement, is that threat a seizure? Well, does the person feel like they're free to walk away from that encounter any time of their choosing? No, they don't. And so that does constitute a seizure under the Fourth Amendment. Now, let's say that you do have a perfectly valid reason for taking a patient to the hospital against his will. You're not quite out of the woods yet. A lawful seizure can quickly become illegal if it is carried out in what's referred to as an unreasonable or extraordinary manner. For example, there were some paramedics in Wyoming a few years ago found themselves in hot water after forcing a suicidal patient to go to the hospital against her will. Now, I know you're probably thinking, wait a minute, we take suicidal patients against their will all the time. How could this get you in trouble with the law? Well, the decision to take her involuntarily wasn't the issue. It was the manner in which they took her, carrying her to the ambulance naked and handcuffed for all of her neighbors to see. That was a big problem, and that was ruled an extraordinary manner of seizing the person, and it got them in trouble with the Fourth Amendment. A while back, there was a case wherein the restraint of a patient without reasonable justification led to a $150,000 lawsuit, and that's just the tip of the iceberg. Any number of legal problems, legal pitfalls can occur if you're not very careful with all of these things. And that brings up the 14th Amendment, which deals with the prohibition against taking someone's life, liberty, or property without due process. And I underline the word liberty. So taking someone to the hospital against their will is considered false imprisonment if you don't have justification for doing so. And while it's true that criminal charges against providers are actually pretty rare when it comes to false imprisonment or kidnapping, civil lawsuits for false imprisonment are pretty common. And as if that weren't enough, the laws governing restraint and involuntary transport, we'll consider it like this. If you restrain a competent patient without just cause, the second you make physical contact with them, that's not just false imprisonment or a seizure. You touch them, and that becomes battery. So it's a serious thing that we need to really consider. All right, let's see if you were paying attention earlier, and if some of the things that you learned in school, if you were taught the correct thing. So here's the first question. If medical control authorizes an involuntary transport or the use of physical or chemical restraint, all liability is transferred to that physician, and the EMS and fire providers, they're protected. Is that true or is that false? That is, in fact, false. It's a mistaken belief that is derived from something that used to be taught pretty prevalently even in EMT school, where we were taught that you are a borrowed servant of the physician. Basically, you're the eyes, ears, and hands of the ER physician. So you're operating under that physician's license. So if you do what he or she tells you to do, you've washed your hands of all responsibility, and the doctor's the one that's on the line for it now. Well, unfortunately, virtually every word of that statement is completely false. We don't have enough time to go into the details. I could do an hour-long lecture on that topic alone, but the bottom line is that regardless of what even a doctor tells you to do, if your actions are a gross departure from the standard of care, and if your patient suffers as a result, or if you violate his civil rights, you could be held civilly or even criminally liable. Doesn't matter what the physician told you to do. If you do something that you should have known was wrong, then you are on the hook as well. So this kind of brings up the topic of immunity. It kind of relates to that, where we think of things that the protections in the law that keep people from being able to arbitrarily sue law enforcement, EMS, fire, and so on. You see, years ago, government officials looked at things and said, well, if a person can sue these first responders anytime they want, no one in their right mind is ever going to want to have those jobs. So they put these immunity protections in place in the law. However, in recent years, the immunity protections are being thrown out in courts. Illinois essentially got rid of it just a few years ago. And the fact of the matter is that even from day one of those immunity laws, there was no protection against suits claiming you violated someone's civil rights or you did something that was grossly negligent. In either case, these immunity protections will not provide you any shielding whatsoever. So why call medical control at all? Just a little side note here. If calling them is not going to protect you, why bother? And the answer is because it can serve as a show of good faith. Think of it as doing your due diligence. You're not getting a get out of jail free card whenever you call medical control, but it is something that you can point to and use as a part of the evidence to show that you are acting in good faith. You are calling a physician to basically get their consultation on the issue because you want to do everything, cross every T, dot every I, to make sure that you are doing what was in the best interest of the patient. So it's just something to put in there as evidence that you are trying your best to act in good faith, and that will oftentimes provide you protection in court. So we talk a lot about these things that can justify involuntary transport, one of which, probably the biggest that we think of, is when a patient poses a likely threat of physical harm to self or others. And as a result of whatever mental impairment or injury, maybe they have a head injury, maybe they're hypoglycemic, maybe they're postictal and they're just not in their right mind. And as a result of that, or a psychiatric condition, if as a result of that, the patient is unable to obtain food, clothing, shelter, or to provide their own medical care, if they are unable to recognize a disease process or something, to appreciate what it is, what's going on, and to seek medical care, if they cannot do those things to protect themselves, in those circumstances, or if they are likely to suffer substantial injury, illness, or psychiatric deterioration unless the treatment is rendered, or that brings us to this term right here. If any of those things are true, as a result of whatever impairment they have going on, they can't provide their basic needs, food, shelter, clothing, they can't seek out medical care, or they don't recognize a medical illness, and that poses a substantial threat that they are going to end up deteriorating because of it. In those cases, they are referred to as having a grave disability. So they may not be an overt threat to themselves or to someone else. They may not be threatening to hurt or kill someone or to commit suicide. But nevertheless, if they don't receive care, their grave disability is likely to lead to serious deterioration or even death. Now, this doesn't mean that there's just a little bit of a possibility that maybe this patient might have something go wrong. It's that more likely than not, they will suffer a disaster as a result of this disability. in which case, if there is a grave disability present, that is a justification for involuntary care and transport. Other things are they attempted or threatened to harm someone or themselves. We've talked about that. Or another thing that can be used as part of justification is they've caused substantial property damage. In other words, they've demonstrated destructive behavior, basically shown that they are not of sound mind. And we'll talk more about that in a moment. And that brings us to this word right here, capacity. So we're going to talk about this, and I'm actually getting ready to show you a video of a patient. And I want you to look at this patient and ask yourself, if this were my patient, what would I have done in that situation? Take a look and we'll talk about it after.
Hey, come over here. Hey, the ambulance is over here. Come on. We're trying to get you help, bud. Go over and see the girls in the ambulance. Come on. Come on. Go over and see the girls in the ambulance. They're going to get you the help. They just want to check your vitals. That's all they're going to do. Come on. That's all they're going to check your vitals. Make sure everything's okay. Have a seat. Have a seat.
You have to talk to us. All right? What's your name? You speak English? Hey. Hey.
That's all of it again. 1 minute he's head up, eyes up, looking around. Next minute head down.
Give me some of me.
Yes, ma'am.
Yeah. Get ready to wake up. Pleasure. How do you want me to have the pleasure? Pop it. Breathe that in.
You don't want it up your nose and talk to me. Stop acting stupid. You're a grown man. Tell me, open your mouth and talk to me. While they're out here on the interstate with you. Hello? Hello? I'm not playing. What's your name? What's your name? What's your name? Hello? What's your name? What's your name?
Speak English?
Yes.
What's your name? It's fine.
All right, so check this out. Can you please tell us your name so you can take this out your notice? I know it stinks. We know it stinks. Come on, partner.
It's just your name.
Everybody here's just trying to help you out, bud.
Hello? What's your name? Everybody's got a name? Yeah?
What's
your
yours?
name?
What's your name? It's okay.
You don't want to say it in front of the police officer?
Want to write your name down? Can you write your name?
If it's an act, it's a pretty good act.
Yeah.
Because I see the same thing when I see a variety of drugs being used.
Yeah.
And if you're taking something, we're not here to judge you.
What you been
We're going to
taking?
get treatment. If you're taking anything, we're going to get treatment for it.
What you been taking?
Yeah, supposedly he was naked on top of the cab of a tractor.
I just want to go ahead to the substation and go to sleep. So if you tell me your name, we'll let you go so I can go back to bed.
She's being serious.
I'm being fucking serious. I'm sleepy. Give me a damn name so I can go home, for real. I'm tired.
Sit here, okay?
Please give me your name so I can go home. I know you know what the hell we're talking about. You're sitting there laughing.
What's your
bullshit.
name?
So tell us your damn name, please.
Rodriguez.
Do you want to go home? Or do you want to go to the hospital? Or do you want to go to jail?
Okay? If you don't want to go to the hospital, you can go with me. Those are your
Start
choices.
Talking in about the next 5 minutes.
It's going to be less than that, because I've been playing this game for far too long. I've been very patient with you. We want to get you some help. That's all we want. Okay? Do you want to go to the hospital? Because if not, you're going with me. That's how I'm going to solve this problem.
What are you looking at me for? You full of shit, bro.
Yeah, he is. Yeah, he is.
You want to talk to us? Yes or no? We know you can talk. We know you can understand us. Now you got to be real with us. What is your
Shake
name?
your head if you do.
Okay.
Go.
Do you want to go to the hospital? Yes or no? Do you want to go to jail?
Well, those are your two
Then come on, I'm going to give you a ride. You don't want to go to the hospital, Leo? So let's go. His vitals are good, ladies?
Yes.
All right.
Have a nice day.
I'm going to give you a ride. Do not walk on the interstate. Walk right on the shoulder of the road. You're not going to jail. You're not under arrest. I'm going to give you a ride. I ain't giving you a ride to jail, because if I was going to give you a ride to jail, you'd be in handcuffs. You're not in handcuffs. You're not under arrest. I'll figure out where you live. Give you a ride to a safe environment. That's all I want. I want to make sure you're all right.
Well, there you go. A very frustrating event, to say the least. First time I saw that video, I thought my blood pressure had gone up about 60 points. So I asked you earlier, if that had been your patient, how would you have responded? Hopefully, it wouldn't have been anything like those providers in the video, because that was just embarrassing. But look at some of the things here that they obviously overlooked. First off, the basic question is, was he behaving with normal behavior? Would you have called that behavior normal or abnormal? And think of it like this. One of the things the police officer pointed out was that he was initially found naked on top of a tractor. That is not normal behavior. And then walking around without a shirt there on the shoulder of the road, also not normal behavior. Not talking or communicating, it's abnormal. And then another thing that they misinterpreted, if you noticed when they were asking him some questions and he shook his head no or nodded his head yes, if you pay real close attention, he is mimicking those gestures that are being performed by the providers asking the questions. They shook their head, he was watching, and then he immediately started shaking his head. That is a common trait with people in a psychiatric disturbance, where sometimes it's referred to as mirroring. It's not an intelligent act that they're performing. It's like a reflex action almost. They observe someone nodding their head, so they mimic it. It doesn't mean that there was a comprehension of the questions they were asking. And in any case, it doesn't seem that at any point in time they considered the possibility that they were looking at someone with a psychiatric illness. And as you saw, it ultimately led to a very severe tragedy. And speaking of disasters and lawsuits, I'm going to take a look at two lawsuits, and I want you to help me compare and contrast these cases, because at first glance, just a little spoiler alert, you're going to look at this and think that the two cases contradict one another. And then we're going to discuss why that may not be the case, actually. So the first case is the case of Brett Weiner. You see him there on the left side of your screen. And the other side of the screen with St. Francis Hospital, that was another case where a New York physician in an ER was sued after a patient was injured. So let me paint the picture here for you. We'll look at Brett's case first. So at the age of 21, Brett is a college student, all-American athlete, but he's battling major depression and he's losing that battle. One night, his condition grows so intense that he begins hearing voices telling him to kill himself. He's taken to a nearby hospital, and the following morning, the nurse arranges to have him transferred to a psychiatric facility. Upon the arrival of EMS, the nurse explains that although Brett had been perfectly compliant for the ER staff, the physician nevertheless considers him to be a flight risk. And so, after introducing themselves to Brett, the EMTs load him into the ambulance. The attendant anchors Brett's wrists to the stretcher using a pair of soft restraints. Then he sits down on the bench seat beside Brett, and the ambulance departs on what's thus far a very classic example of an unremarkable run-of-the-mill routine psych transfer, indistinguishable from thousands of others just like it. But as Murphy's Law states, if it can go wrong, eventually it will. So about 10 minutes into the trip, Brett asks the attendant who's sitting beside him, "Could you move to the seat behind me, because having you sit right beside me like that's making me very uncomfortable?" And the EMT says, "Oh yeah, sure, I don't want to make you anxious." So he gets up and moves from the bench seat to the captain's chair back behind the stretcher. A few minutes later, the EMT receives a very unpleasant surprise when he finds Brett standing straight up in the back of the ambulance, free from both of his restraints. Quickly, the attendant grabs Brett and struggles to keep him inside the ambulance. The driver, hearing the commotion, radios for help and pulls the ambulance off to the side of the highway and onto the shoulder. And Brett manages to pull free and escape, sprints across 7 lanes of interstate traffic, and keeps on running. Amazingly, there happened to be an off-duty police officer nearby who catches wind of this, and he gives chase and manages to apprehend Brett only a few minutes later. The two talk for a few minutes, and the officer, feeling like he's calmed Brett down, begins to escort him back toward the waiting ambulance. And just before they reach the roadway, Brett pulls away from the officer, steps into oncoming traffic, right into the path of an oncoming pickup truck. He's struck and killed and pronounced dead right there on the scene. And then only about 18 months later, that EMT finds himself standing in a courtroom where a jury has just found him guilty of gross negligence and has awarded Brett's family a $1 million judgment. And just like that, that EMT's career was over. So compare that to this other case, Kowalski versus St. Francis Hospital. So this was a hospital in New York, and a patient is intoxicated and wants to be admitted to a detox facility. So a friend drives him to the ER, and he's alert and manages to walk without help, all of that sort of thing. But his blood alcohol level is off the charts. He is obviously drunk. He's taken to a room where the physician visits with him for a bit and agrees to admit him to the hospital's detox program. And then the physician goes off for a little while, and just like any ER, you can expect you're going to be waiting around for a while. Well, the patient sits in the ER for about 4 hours awaiting transport to detox before he decides he's waited long enough. He removes his IV and tells his nurse he's leaving. The nurse asks him to wait for just a moment so she can go tell the doctor. Patient agrees to wait. The nurse goes to find the doctor, but when she returns a few minutes later, patient's already gone. She rushes back to the doctor and says, Do you want me to call the police? And the doctor says, no. Well, long story short, after walking away from the hospital without any escort, the patient is struck by a car less than 2 hours later and severely injured. Well, Kowalski sues the hospital and the physician. His attorney argues that because Kowalski was drunk, the doctor should have protected him from himself. So, who do you think won this lawsuit? The doctor being sued, or Kowalski, the drunk who had been struck by a car? Well, the court ruled that the physician had no right to hold Kowalski against his will, in spite of being intoxicated. But wait a minute, how can that be? The patient was drunk. It was a known fact that his blood alcohol level was high. Wouldn't that be enough to justify treating him as an involuntary patient, at least until he sobered up? Well, that's not how the court felt. They looked at the situation and determined that the patient was enough of sound mind to make his own informed decisions. Now, I don't know what test the doctor used to assess this patient's mental capacity. That information wasn't available to me. But whatever it was, he ascertained that this patient had mental capacity, the ability to understand the risks and the consequences of his decisions, and to make an informed decision or an informed refusal of care. And because of that, it would have been illegal, a violation of the patient's civil rights, to hold him against his will. That was the court's judgment. But now, looking at these two cases together, it really makes it seem like there's a contradiction here, right? You've got a suicidal patient in one case that escapes the ambulance and dies. The EMT is found liable and is judged to be grossly negligent. A drunk patient leaves the ER AMA, is struck by a car, and the physician is found not liable. And the court says he had no authority to hold the patient against his will. So what on earth? How did this happen? What's the difference? So let's talk about Brett for just a second here. Why gross negligence? What led the jury to that conclusion? Was it because the EMT failed to prevent Brett's escape and ultimately his death? I mean, did the jury feel that it was the EMT's responsibility to dogpile on top of Brett and hold him to the floor of the ambulance for all he had? Or was the problem that he applied and monitored the restraint devices improperly? Well, I'm sure you guessed it. It was B. See, in the jury's opinion, there were two preventable errors that conceivably could have prevented this disaster from happening. First, he allegedly, the EMT, applied the soft restraints incorrectly. Second, the big problem here was when he moved from the bench seat, a position that afforded him an unobstructed view of Brett's restrained limbs, to the captain's chair, which, with Brett in the semi-Fowler's position, impeded the EMT's view of the restraints. The jury believed that if not for those choices, Brett's death could have been prevented. So let's compare the two cases a little bit more here. So in Brett's case, you have a patient who is suicidal, who has admitted having suicidal thoughts and hearing voices. In Kowalski, there was no overt imminent threat. Now, what do I mean by imminent? This is what I kind of alluded to earlier. The threat has to be imminent, meaning more likely than not, a bad outcome is going to happen. Not that it could happen. I mean, I could walk out the door here today and get struck by a meteor, but that's not more likely to happen than not. You see the difference? The threat has to be imminent, and it wasn't in Kowalski's case. Brett was delusional. He was hallucinating, hearing voices, And in Kowalski's case, he had mental and legal capacity to make his own decisions. So in the end, Brett's involuntary care was justified. Involuntary care was not justified in Kowalski's case. So when it comes to making a decision of whether or not to take someone to the hospital and provide care against their will, the big element you have to consider is capacity. Capacity is the term that we use when we're talking about whether the patient has the ability to understand the situation, to understand the risks or benefits of their decisions, and is able to communicate their understanding back to you. So looking here, I want to point out a couple of things. First off, just because a patient has a psychiatric illness does not mean they immediately lack capacity. If they are well medicated and they are lucid in the moment, they possess their faculties, they have the capacity to choose for themselves. Now, what about an accidental heroin overdose where the patient is lucid after receiving Narcan? Can that patient in that moment say, I don't want to go to the hospital? Well, in recent years, we've tried to underscore this and to clarify the fact that, yes, indeed, if a patient becomes lucid after Narcan, they do have the right to refuse treatment and transport afterwards. But they have to be able to understand the risks that you communicate to them. Hey, that Narcan could wear off and you could go right back into being comatose here. It could end up stopping your breathing. You could die. And the patient's able to communicate, yeah, I understand the risks. I could die from this possibly or whatever, but I still don't want to go to the hospital. I'm choosing to take that risk. If they're able to communicate that and their decision remains stable over time, they don't like flip-flop back and forth. Oh, yeah, maybe I'll go to the hospital. No, I don't want to go to the hospital. Yeah, maybe I should go to the hospital. You know, that kind of thing. They're able to make a clear and final decision and understand the risks and benefits. In those cases, yes, you have to honor their request. There was an attorney that really captured the issue here, and I'm going to just read his statement in full. Providers must respect the legal rights of all patients, and that includes those who present with mental health or intoxication issues. We can't take a paternalistic approach and hold someone against their will because that's what we think is best for them. We assess them to determine if there is immediate risk of injury to themselves or others, and the decision to involuntarily detain them is based upon that determination alone. If the determination is that the patient does not pose an immediate risk, we then explain the risks, the benefits, and alternatives of leaving against our advice, and we document that conversation. But patients have the right to make their own decisions about staying or leaving. The laws regarding patient rights reflect a culture that values autonomy and respect for a patient's ability to make decisions regarding their own health care. So there you have it. Does the patient have capacity? That's really the only decision that you have to make, the only question you need to answer when you're trying to determine whether or not you have justification to take someone involuntarily to the hospital. So now that I've left everybody terrified to ever place someone in restraints or transport them to the hospital against their will ever again, let's take a look at things from the other side, because that's an imbalanced view. We want to look at some things that justify involuntary transport and the use of patient restraint. That's what I refer to as the initially cooperative patient. I've read somewhere in the neighborhood of 200 to 250 assault reports where it talks about an EMT, paramedic, firefighter who was assaulted on scene by a patient. And I wanted to see if there were any common threads and if there was anything we could look for and say that is a risk where if we see this thing present with the patient, there is a greater risk of being assaulted here on this scene. And I found some really interesting things in that informal study. So for a moment, though, I want to try something here, a little experiment with you. We're going to do a little bit of a magic trick, okay? I'm going to read your mind, okay? So I hope everybody's paying real close attention here because we're going to have to do some math, okay? This is the most complicated thing you're going to have to do this morning, I promise. Think of a number between 1 and 10. Have you got that number? Take that number and multiply it by 2. Next, add 8. Divide that number by 2. And then subtract the original number, the one you picked between 1 and 10. All right, so your final number here, keep that in your head. I want you to look at this table and find your number and the corresponding letter on the table. All right. Think of a country that starts with that letter. Take the second letter of that country's name, and think of an animal that starts with that letter. And then lastly, think of the color of the animal. So I, in my great psychic wisdom here and ability, I think I can determine what it was that you were thinking of. I believe that you were thinking of an elephant in Denmark. I know everybody's like super impressed right now. Obviously, this is not real magic. It's not real psychic ability or anything like that. In fact, it's nothing more than mathematics, probabilities, and just a general idea about statistical facts. For one thing, there are only 4 countries in the world that start with the letter D. Denmark, Djibouti, Dominica, and the Dominican Republic. And statistically, in our hemisphere, we are more likely to think of Denmark over the others. So it was just a probability. And then the rest is just math. Real quick, we are going to take a 10-minute break here. So go ahead, take 10 minutes, get yourself a caffeine infusion, and we'll be right back.